All rise.
All rise. Judges of Guyana Court of Justice.
Please take your seats.
Mr. O'Neill, you can call the case.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana, CCJ application number 9 of 2018, between Arnold Sankar versus the Guyana Rice Development Board. For judgment this afternoon. Can we have the appearances for the court, please? Thank you.
May it please Your Honours, Mr. Mawakir Arnold Sankar and I appear for the applicant.
If it please Your Honours, Timothy Jonas, for the respondent.
Yes, thank you, gentlemen. The majority judgment will be given by Justice Rashford, and she will indicate, I think, yeah, she will also indicate the dissent and summarize.
Thank you, Justice Witt. This summary is not intended to be a substitute for the reasons of the court or to be used in any later consideration of the court's reasons. Mr. Arnold Sankar, the applicant in this matter, sought special leave pursuant to Section 8 of the Caribbean Court of Justice Act to appeal against a decision of the Court of Appeal of Guyana, which gave to the Guyana Rice Development Board, the respondent, an extension of time to apply for leave to appeal against a decision of the full court and leave to appeal that decision after a delay of some 5.5 months. The substantive matter concerned an action filed by Mr. Sankar in 2016 for the alleged breach of an agreement for the sale and purchase of rice paddy between Mr. Sankar and the board. The claim was commenced by a specially endorsed writ together with a statement of claim and an affidavit verifying the claim, and sought special damages in the amount of Guyana dollars 99,670,273, together with interests and costs. The specially endorsed writ was fixed for hearing on the 19th of January 2017. At that hearing, the board, represented at that time by the chambers of the Attorney General, sought and obtained leave to file and serve its affidavit of defense within 14 days. The proceedings were adjourned to 2nd March 2017 for hearing. When the matter came up for hearing on the 2nd of March 2017, the board had not yet filed its affidavit of defense. The trial judge in Sonali J, on her own motion, gave the board 14 days final leave to file its affidavit of defense, failing which judgment would be entered for Mr. Sankar. In breach of this order, the board filed and served its affidavit of defense on the 10th of April 2017. On 18th April 2017, Mr. Sankar filed and served a summons and an affidavit in support, seeking an order that the affidavit of defense be struck out for failure to comply with the unless order, and an order that judgment be entered in his favor. When the matter came up for hearing on the 20th of April 2017, the board filed an affidavit in answer. The matter was adjourned from open court into chambers after the board requested that the judge determine the summons before entering judgment. In chambers, Sonali J struck out the affidavit in answer on the basis that Mr. Sidney James, head of the Specialized Organized Crime Unit, did not have the authority to depose to the affidavit. Sonali J then granted the board 14 days leave to file and serve an affidavit in answer. On 2nd May 2017, the board refiled the affidavit in answer, as well as a summons seeking an extension of time as provided for by the provisions of Order 12C, Rule 7 of the High Court Amendment Rules 2006 to file and serve its affidavit of defense. On 21st July 2017, in Sonali J recalled the unless order on the basis that there was inherent discretion in the court to decide whether or not to enforce it, even though the board had not applied for relief from sanctions. She did, however, award costs against the board in the sum of Guyana dollars 50,000 for its failure to file the affidavit of defense within the specified time and the wasting of the court's time to hear further applications to determine the issue. Mr. Sankar appealed to the full court of the Supreme Court. The full court found that the result of her judgment was that Mr. Sankar was denied the benefit of the remedy provided for by Order 12, Rule 7 of the High Court Amendment Rules 2006. It also found that Rule 7 clearly expressed that any sanctions for non-compliance had effect unless the party in default applied for and obtained relief from sanctions, and no such application was made by the board. Lastly, the full court considered whether the court had an inherent jurisdiction to assist a party who had failed to comply with an unless order and had also failed to seek relief from sanctions. The full court concluded that the time had come for parties to understand the consequences of non-compliance, and they cited the views expressed in Texan Management against Pacific Electrical Wire and Cable Company Limited. As a result, judgment was granted in Mr. Sankar's favor in the terms stated in the statement of claim, and costs awarded in his favor in the sum of Guyana dollars 50,000. The board initiated proceedings to appeal against the decision of the full court, but this was marred by delay. Despite the delay of some 6 months, the Court of Appeal, citing Persaud and another against Muhabir and another, was satisfied that the reasons for the delay were due substantially to the errors and mistakes of the board's then counsel. The Court of Appeal also found that there was a reasonable chance of success in the appeal. In its view, the affidavit of defense disclosed tribal issues in the underlying action, and the issues concerning the unless order made by Insanali J required consideration by the Court of Appeal. As to the degree of prejudice, the Court of Appeal held that on the face of the proceedings, Mr. Sankar would not suffer a miscarriage of justice if leave to appeal out of time was granted. The Court of Appeal also found that the important procedural issue involved was also an exceptional circumstance justifying the extension of time to appeal. The Court of Appeal ordered that the board be granted leave to appeal within 7 days, with costs to Mr. Sankar in the sum of Guyana dollars 100,000. In its judgment delivered by Rajnathli JCCJ, this court first acknowledged that there was an overarching jurisdiction in the Court of Appeal under Order 1, Rule 8 to enlarge time when the interests of justice required it. The issue of contention between the parties was not, therefore, whether the jurisdiction existed, but rather whether the discretion to enlarge time under Order 1, Rule 8 of the Court of Appeal rules should have been exercised by the Court of Appeal in the circumstances of this case. The court relied on the case of Hing and Hing, where the Court of Appeal of Guyana considered the discretionary power given by Order 1, Rule 8, and noted that in arriving at a determination as to what was required in the interests of justice, a court should balance the interests of the dissatisfied litigant who wished to pursue a right of appeal on the one hand, with the interests of the successful litigant who wished to have the satisfaction of the judgment in his favor without undue delay on the other hand. In addition, the court should have regard to the important administrative principle against the undue protraction of litigation. Given the circumstances of this case, the court found that the Court of Appeal reached a conclusion which best served the interests of justice when it ordered that the board be granted an extension of time to seek leave to appeal and granted leave to appeal. The court agreed with Mr. Jonas, counsel for the board, that several issues raised by him required consideration by the Court of Appeal. 1. Whether Mr. Sankar's claim, which was instituted by way of specially endorsed writ, was outside the parameters of Order 4, Rule 6 of the High Court Rules 1955, because it was a claim for damages for breach of contract and not a debt or liquidated demand as required by those rules. 2. Whether there were discrepancies in the statement of claim, including the way in which the sum claimed was calculated. And 3. Whether the full court was correct to set aside the decision of Incinali J to grant an extension of time for the board to file its affidavit of defense in the circumstances in which Incinali J had made and recalled the unless order. Indeed, the court found that the board's challenge to the unless order made by the judge and the findings of the full court on that particular point were important issues which ought to be determined by the Court of Appeal of Guyana. As such, the Court of Appeal was entitled to grant to the board an extension of time to seek leave to appeal and leave to appeal in the interest of justice in accordance with Order 1, Rule 8 of the Court of Appeal rules. In those circumstances, Mr. Sankar failed to convince the court that he had a realistic prospect of successfully appealing the judgment of the Court of Appeal. Therefore, the application for special leave was refused. In a separate opinion, Barrow J. CCJ found that given the facts of the case, special leave should be granted to Mr. Sankar, as Mr. Sankar had shown a realistic prospect of successfully arguing before the court that the Court of Appeal erred in law in extending time when there was no better excuse than it was counsel's fault. This approach arguably conflicted with the decision of this court in Mitchell against Wilson, in which was stated that the error of counsel will rarely, if ever, provide a good excuse for non-compliance with time limits. Justice Barrow then went on to consider the merits of Mr. Sankar's appeal to the CCJ. He found that because the board had filed a defense before Mr. Sankar applied for judgment, the judge was entitled to withdraw her unless order and retroactively extend time for filing the defense. For that reason, Mr. Sankar failed in his argument that the Court of Appeal misled itself into thinking that the board had a reasonable prospect of success on appeal. The Court of Appeal had the jurisdiction to extend time and correctly exercise his discretion in granting the orders. Accordingly, he would have dismissed the appeal. In the circumstances, the court made the following orders. 1, the application for special leave is dismissed. 2, for the avoidance of doubt, the Guyana Rice Development Board, in accordance with the judgment of the Court of Appeal, is granting an extension of time to seek leave to appeal and leave to appeal the decision of the full court of the Supreme Court to the Court of Appeal within 7 days from the delivery of this judgment, if it has not already done so. 3, as to costs, the order of the Court of Appeal is affirmed. And 4, each party will bear its own costs of this application. Thank you very much, Counsel. Justice Smith.
Thank you, Justice Rajmukhi. Gentlemen, and this was only summary.
Very grateful to your honors.
Maybe it would be good if we all stuck to the timeline, then we didn't have to spend so much time on these matters that really take away from the matters that really matter. But anyway, I suppose you would agree with that. Did you already receive the judgment?
Yes, Mr. It was sent to us about an hour ago.
Okay, well then, the only thing I need to say to make it very clear, you won't see Justice Hayton, but he was very much part of this panel, and he was involved in all the deliberations. Nowadays, you don't have to be in a safe place to do that, as you probably know. And so he also signed and authorized the signature of this judgment. And that is all I can say now. There's nothing else you want to add?
No, please, thank you very much.
Okay, gentlemen.
Thank you, sir.
Court rise.